contest the allocation of $2 billion in damages to athletes by appealing the NCAA settlement. Attorneys for 8 female athletes who challenged the NCAA and Power 5 conference's settlement of 3 athlete compensation antitrust cases filed notice on Wednesday, June 11 that they would appeal a federal district judge's decision to give the deal final approval. The Ninth U.S. Circuit Court of Appeals will not contest the settlement's future provisions, which let schools to compensate athletes directly for the use of their name, image, and likeness starting on July 1, lawyer John Clune told USA Today Sports. It will challenge, under federal gender equity law, the legality of how more than $2 billion in damages is set to be distributed to current and former athletes who are unable to participate in nil contracts. About 90% of that money is set to be paid to football and men's basketball players because the damages model created by the plaintiffs' economic experts is based on their assessment that the market for college athletes' nil compensation historically has been driven by revenues connected to those two sports. The attorneys for these objectors contended in a January filing that those payments would have been required to be made proportionately to male and female athletes due to Title IX if there had been no regulations prohibiting colleges from paying athletes nil compensation. In her ruling that granted final approval of the settlement, U.S. District Judge Claudia Wilken disagreed, writing, "The objectors have cited no authority that Title IX applies to damages awards distributions made by a claims administrator are subject to Title IX. Accordingly, the court cannot conclude that Title IX violations will occur when the gross settlement fund is distributed by the claims administrator pursuant to the damages allocations that plaintiffs have proposed." The appeal might cause a considerable delay in the payment of damages to tens of thousands of athletes and the plaintiffs' attorneys, who have asked to receive hundreds of millions of dollars from the $2.8 billion settlement pool. These payments will all be made over a 10-year period. The NCAA and the conferences would start paying damages in the event of an appeal of this kind, according to the settlement Wilken approved. However, the funds would be kept in escrow and not dispersed to athletes or attorneys until the appeals process was over. In a statement June 11, objectors' lawyers Clune and Ashley Hare said, "We support a settlement of the case, just not an inaccurate one that violates federal law. The calculation of damages is based on an error to the tune of $1.1 billion. Paying out the money as proposed would be a massive error that would cause irreparable harm to women's sports. This is a football and basketball damages settlement. Period." Title IX was created to rein in efforts such as these. Congress has expressly rejected efforts to exempt revenue-generating sports like football and basketball from Title IX's anti-discrimination mandate. This is regrettable because these attorneys are now delaying payments to hundreds of thousands of athletes in order to file an appeal on a Title IX issue that the judge resolved promptly and correctly, said Steve Berman, one of the lead attorneys for the athlete plaintiffs in the cases being settled, in an email to USA Today Sports. This lawsuit was about antitrust, not Title IX. Instead of taking over the payments to collegiate athletes, these attorneys ought to bring the Title IX lawsuit if they believe it was so strong. Thanks for watching USA Signal, your source for real news, real fast. Don't forget to like, share, and subscribe.